Thank you very much indeed for joining us. I'm delighted to chair this very interesting Society of Labour Lawyers Employment Group meeting. I'm delighted that we've been able to secure the input of such great speakers. We've got Gus Baker, who is a barrister at Outer Temple Chambers, who is going to speak to us about the law surrounding safe returns to work. We've got Charlotte Harwood, who is an employment solicitor at the Plumstead Community Law Centre, and she's going to talk to us about the practicalities of securing employment justice given the state of the employment tribunals. And finally, I'm delighted that we're joined by the National Head of Health, Safety and Environment at the GMB Union, Dan Shears, who's going to talk to us, to use a rather old expression, about life at the coal face, and perhaps to use a more modern one, life on the shop floor. So as you'll know, the topic for today is safe returns to work. If you've got any questions, what we'll do is, if you raise your hand using that function on Zoom, at the end of the talks, which will last about 30 minutes, Joe will bring you in as a participant, and you can ask your question to whoever it is you want to ask your question to, and we'll do that in groups of 3. If you've got a difficulty doing that, you can also write your question, and then I will ask it on your behalf. So without any further ado, we'll go first to Gus.
Graham, thank you very much. And thank you everyone for tuning in to what I hope is an interesting 10-minute talk on a section of the Employment Rights Act that is rarely, if ever, used, very rarely used. I've come across it in 1 or 2 cases before, and it's section 100 that deals with health and safety dismissals, and section 44 that deals with health and safety detriments. Now, in the past, these sections have been used for things going bang in the workplace. To put things quite crudely, explosions, obvious dangers. And there's never been a case that I've found where an infectious disease has been said to constitute a danger under the sections. But my view is they actually provide quite extensive protection for employees whose employer isn't following reasonable health and safety practices, not just the government guidance, but going a bit further to take care of individuals' health and safety. Now, we all know that implied in every contract of employment, there is a term that the employer will take reasonable steps to look after his or her employees' health and safety. And in the past, in office environments and for estate agents and for people who are unlikely to deal with things that are very obviously dangerous, that's never played too great a role, slipping and tripping hazards. But during a pandemic, especially when the virus was more prevalent, actually those health and safety steps are incredibly important, because if you don't take protections, your employees could contract a very serious and sometimes fatal virus. So the test at section 101D of the Act is in circumstances of danger. Well, I'll pause there. Coronavirus is capable of being dangerous, it seems to me. Then the next bit of the test is danger which the employee reasonably believed to be serious and imminent. So let's break that down into 2 steps. Does the employee have a belief that the danger from coronavirus is serious and imminent? Well, that is a wholly subjective question. Did you think, were you really scared of coronavirus when you did whatever you did? Is a good question to ask. Now, if the answer is yes, and someone thinks, yeah, I was really scared of getting it, I thought I might get it from anyone I came across in the workplace, any moment, and I knew that coronavirus is pretty serious, then that person will have a belief that coronavirus was a serious and imminent danger. The next and more difficult bit of the test, a more unpredictable bit of the test, is whether that belief was reasonable. And whether a belief in serious and imminent danger from coronavirus is reasonable is obviously a difficult question of fact. So if you were working as a porter on a coronavirus ward in April, I reckon you've got pretty good prospects of showing that your belief that coronavirus posed a serious and imminent danger was reasonable. But if you're a home worker in July, not instructed to leave the house, probably not. Now, everyone will have different views of risk. I'm sure everyone who's listening have friends who are more risk averse than them and are less risk averse than them. So it'll be a really interesting question when it's reasonable to think that there's serious and imminent danger from coronavirus. But one very helpful argument for claimants to advance is that in the coronavirus brackets health protection regulations 2020, the secondary legislation that the government has put in place under the 1984 Health Act is contingent on the government having made a statutory declaration that coronavirus poses a serious and imminent threat to public health. And those are the words. The Secretary of State declared, I think it was on the 20th of February, that coronavirus was a serious and imminent threat to public health. Now, that's not determinative of the question under the Employment Rights Act as to whether a belief that coronavirus was a serious and imminent threat to someone is reasonable, but it's pretty helpful if you're a claimant to be able to say, well, the Secretary of State's made a statutory declaration that coronavirus poses a serious and imminent threat. Therefore, my belief that it posed a serious and imminent threat was reasonable. That's a pretty good argument. But that's not the end of the story. Because even if you can get through all of that, before you can take any protective conduct yourself, you need to show for subsection D that it's danger that you could not reasonably have been expected to avert. Now, my view is that that's a test that the courts are going to look at. Well, what could you reasonably do? Did the employer provide protections for you in the workplace? Social distancing, hand washing facilities, all of the things that you might expect, screens for shop workers. If the employer provides none of that, and a shop worker says, well, I reasonably thought there was a serious and imminent danger from coronavirus to me because I know how many shop workers have died, and I know in the town in which I am, there's still coronavirus circulating freely, and my employer hasn't done anything to protect me from it, then I think they will have a reasonable belief that there's serious and imminent danger from coronavirus that they couldn't reasonably be expected to avoid. And if that is the case, then they can go home. They can refuse to return to the place of work or any dangerous part of it, or leave the workplace. And if they're subjected to a detriment under Section 44 or dismissed because of going home under Section 100, that will be unlawful and remedies will flow from it. The other important right is a right to take appropriate steps in circumstances of serious and imminent danger, circumstances of danger which the employee reasonably believed to be serious and imminent. And whether a step is appropriate or not is to be judged by reference to all the circumstances. But if you take action as an employee, maybe you're the manager of a Tesco store that says no more people in the store than this, because then no one will be able to comply with social distancing. If you do something like that in response to what you think is serious and imminent danger from coronavirus, again, you should be protected from detriment or dismissal if a tribunal concludes that what you did was appropriate with regards to all the circumstances. So these are unusual provisions of the Employment Rights Act for employment lawyers to think about. But I think they're going to become more and more important as we deal with the pandemic and as any cases spike or resurge. And actually, even though they're complicated and even though they are not commonly used, I actually think there's a degree of common sense about them. If you are in a place where you can reasonably show that there is danger from coronavirus, it's obviously serious. If you can show that it's imminent because there's cases circulating around where you are at relatively high levels and your employer doesn't take steps to protect you, well then, in those circumstances, if there's nothing that you can do to protect yourself from what you reasonably consider to be serious and imminent danger, you have quite broad rights to refuse to turn up or to go home. And I'll end on an interesting and difficult bit of what hopefully will be political controversy, and I note that there's a judicial review about this. These sections of legislation explicitly refer to employees rather than workers. And as we know, many people fall into the definition of workers, and many of the people who will be particularly exposed to coronavirus fall into the definition of workers, casuals, people who work for delivery apps, etc. The European legislation that the provisions implement refer to workers, not employees. So there is an interesting argument before the High Court at the moment that the Health and Safety Directive, which the Act implements, hasn't been properly implemented. And what workers can and should argue, if they have these cases, is that on what's called a mal-leasing interpretation, tribunals should read the word employees under this section of the Act as if it applied to workers as well. That will be controversial. To some extent, it will be decided by the High Court in the litigation brought by the IWGB, but not to a full extent. But I think that anyone here who's advising employees should make reference to these sections and should know that they do provide quite wide rights. And I have to say, surprisingly wide rights. And whenever employment tribunals get round to considering these cases, I imagine it will be late 2022, we'll see exactly how they're construed in the circumstances. So Grahame, thank you very much for giving me the opportunity to ramble like that. And if anyone has any specific questions on these sub-provisions, I'm very happy to answer them either here or via email later.
Thank you, Gus. More or less to time there. And on that last comment about it taking until 2022 to get anything decided, let's move on to Charlotte, who's going to talk to us about employment tribunals.
Thank you very much, Grahame and Gus. Yes, that was a very appropriate end to your talk there, Gus. Just to introduce myself, I'm a solicitor at a law centre in South East London. It's important to note that my anecdotes, that when I refer to them, are going to be London-centric, just because that's the area I serve. And it's very important to note that the different regions of the employment tribunals are dealing with the matters slightly differently. I will talk about that as I go along. So I solely advise claimants, both representing my own clients and both advising litigants in person. So I can see from both sides when people do have to represent themselves, it adds a whole other layer of difficulty. Now, as you know, the employment tribunals were still going through a period of huge change. We were still dealing with the increased cases from the removal of the employment tribunal fees without adequately increasing infrastructure such as the judiciary or the admin staff. So this was all going on prior to coronavirus, and obviously now we've had this other massive delay come in that's increased the problems. As I'm sure you're all aware, a decision was made to turn all hearings into case management hearings between the 23rd of March and the 26th of June. So this was a decision made partly because the courts did not want to simply pause everything, as was suggested by some, but that they did not have the infrastructure and the equipment to move immediately to remote hearings, because you have to have equipment, you have to have technology, and you have to have training. And it's worth noting that whilst it's much better now that we're in July, it still is not perfect, and it still very much is a work in progress. And as I go through, there's a lot of things I'm going to talk about, but I want everyone to think about the concept of a work in progress and how we can advocate for change and for how things should be done. Now, I did mention that some regions are doing slightly differently. Now, the Scotland, Wales, East Midlands and West England regions are reportedly way ahead of everyone else. Apparently they're doing full hearings via video, whilst this is unimaginable for other areas. The southeast of England and London South are reportedly currently two regions which can't have 3-day hearings by mid-2021. So they're already full up to that point for 3-day hearings or more. Now, anyone who has done any litigation will know that if you put a claim in tomorrow, the idea of getting a hearing by mid-2021 was optimistic anyway, given that notice of claim takes months to be sent out, the ET3 to be sent to the claimant takes months to be sent out. We are dealing with incredible delays here. And this was really brought home when I was very excitedly calling a client to tell her that I'd got her judicial mediation December and a potential hearing in spring of next year. And I thought this was fantastic. I thought this was quite quick work. She was horrified, and it just really did bring home how used I have got to the incredible delays that we're facing. So worth bearing in mind that we shouldn't have to put up with this. The tribunals are completely overwhelmed administratively. Posts may go unanswered for months. You could be calling the ET multiple times in a day and not get an answer. This is frustrating for people who are represented, because obviously the solicitor is frustrating for them, but for litigants in person, this can be absolutely terrifying. We do need to bear this in mind when we're giving advice. Now, Gus gave a very good overview of the law, and I think my job here today is to give a more down-to-earth view of what is actually happening on the floor and how we need to think really very tactically about how to bring claims. And one thing that's very important for me to mention is that we need to recognise that clients need money and employment. If we say you can leave, we also have to be saying you might be losing your job and you might be going on to universal credit, which we all know is just not adequate for living purposes. Now, I'm not saying to suggest that you ever put your clients in any danger, but we need to take a very holistic approach and make sure that if options like negotiation and mediation are open to us, that we do engage with these processes. Another thing to mention is that with the huge delays, we really need to be pushing for our clients to get support for their mental health needs. Long tribunal hearings, that the whole period of time, from 12 to 18 months in some cases, can be incredibly tough on claimants' mental health. And we really need to be making sure that they're aware of that when they go into litigation. Now, I have a few ideas about working within the limits of the employment tribunals as they are. I found that case management discussions can be very useful if you can get the other party on board, and communication is key. So obviously it's luck of the draw a bit with the other side, but these can be really useful. And one thing that has been very useful to me is trying to isolate certain issues that can be decided at preliminary hearings, which means that they can get heard earlier, and then there's scope for negotiations to follow. Obviously, this is not appropriate in all cases, but it's definitely worth considering and having a discussion in a case management discussion over whether the case can be heard in part a bit earlier through a preliminary hearing for a certain issue. Judicial mediation, of course, you're going to get a date faster than a hearing. What we need to remember as advocates here is that we need radical solutions to address this backlog. So we need to be engaging in ET user groups, any consultations that come up, because we need to make sure that it's very clear what's happening. Of course, the Employment Tribunal is aware, but we need to constantly advocate for access to justice to continue to be a real thing in this country. There is currently a discussion happening on extending the hours of the Employment Tribunal. So preliminary hearings after 4, Saturday hearings, that sort of thing. If you ever see a discussion or consultation, I urge you to get involved and to advocate for yourself and to your colleagues as well. Now, a key problem that we in the social welfare sector are very concerned about is the concerns of the digitally excluded being disproportionately negatively affected. Now, I do have claimants who have no access to the internet, no access to laptops, no access to smartphones. This can be due to issues such as disability or age preventing such good access. It can also be due to poverty. We really need to advocate to those who just simply cannot engage with this process. And as we move into remote working, it's going to be harder and harder for them to be part of it. We need to remember that clients are going to want their day in court. This is a bit of a difficult one because we know that obviously a hearing is not always a very satisfying thing for a claimant, but we do need to be aware when we're advising that might be what they want. And if they're not going to get it, that needs to be something we need to be discussing at the beginning. Now, I did want to raise, just for everyone to be aware, that I've seen a few problems with translators in the Employment Tribunal on the telephone, where I had a recent client. He's a litigant in person and he's being helped by a community advocate. And he actually called her in the middle of a hearing saying, I don't think they even know I'm on the call. I have no idea what's going on. Shall I just put the phone down? He actually got criticised by the judge for not complying. This man had no idea what was going on. The translator was not being adequate. And I think if you're in person, you can see when someone's completely out of depth. On the telephone, it's much, much harder. So we do need to bear that in mind when advising people, especially litigants in person. Now, Graham, I'm so sorry, I didn't check the time before I started. Could you give me a time check, please? Oh, you're muted.
Yeah. You've probably been going for about 8 minutes.
Okay, thank you very much. Yesterday, there was a very useful ELA webinar where Judge Barry Clark said that the pandemic had exposed the fragility of the infrastructure of the employment tribunals. I do not think that this is the only thing in employment tribunal and in the employment law world that has been exposed by this pandemic. And a key issue that I really want to mention today is enforcement. Now, we all know that enforcement can be tricky. There was a research paper done, I think it was a few years ago, that found that 50% of employment tribunal awards were not being enforced. I'm hoping it's not that large now, but I have had trouble with multiple claimants who haven't been able to enforce awards. Now, we really need to think, what is the point of going through 18 months of a tribunal if simply to get someone a piece of paper? And claims where this really needs to be watched out for is where you get companies where you have a director with about 10 different companies. They mix and match contracts. Who knows who the people are actually employed by? It's a real problem. And it was a problem for years prior to this pandemic. But now these are the companies who haven't been able to get help from the furlough scheme because they have discrepancies in their payroll. They probably haven't been paying their taxes. They probably haven't put anyone on payroll. And sometimes the companies have only just been made, even though you have employees apparently working for several years. So they are the people that are coming through my door at the moment. And enforcement is going to be tricky. I honestly don't know how to enforce against someone who might have shut their company, or we have a PO box address for a director, and that's the only thing that we can find. So in those situations, I think negotiations are key when possible, because we want our clients to get something and not nothing. There's one thing that I want to raise before I finish. And I know I'm not painting a particularly good picture here. We need to think tactically. Delays are inevitable. Companies not being able to pay awards or not having awards against them met is a likelihood. We also need to bear in mind that delays in the employment tribunal might lead to criticism. This may give strength to the argument to introduce employment tribunal fees again. So I think we really need to be alive to this and need to be very wary of proposals and fully engage in activism, consultations, petitions, etc., to make sure that this isn't used as an excuse to further deplete access to justice. So I'm not painting a positive picture, but I do think that we're all in a very a pivotal point here with the employment tribunals. And I think we all need to work together and very much get involved to advocate for those who can't advocate for themselves, to improve this system that we have before it's lost beyond recognition. Thank you.
Charlotte, thank you very much. I should say that I've been doing some work with some of the shadow front bench, and one of the issues is, as you may have seen, there was a leaked article in the Financial Times, or rather there was an article about a leak that suggested the Tories were absolutely looking at bringing back tribunal fees. So there's another happy note to end on. Dan, over to you, please.
Thank you very much, Graham, and good evening, everyone. And thank you to Charlotte and Gus for excellent summaries there. That's been incredibly useful. I'm afraid that whilst what I'm about to say will build off of those two presentations, it's not going to add a particularly great veneer of positivity to proceedings. If I'd been doing a PowerPoint for tonight, it would have been entitled Fear and Loathing in Coronavirus Britain, because the report back from the shop floor is one of, frankly, bewilderment, confusion, fear, great uncertainty, and almost a rising tide of feeling that employees are not being looked after, workers are not being protected, and some of the social trust, some of the social bonds between workers and the people they work for and employed by really is deteriorating quite quickly through this. You probably all know the GMB is a general union. We've got members across every part of the economy. As a result, it's been very, very useful to be able to take a broad view of how the last few months have played out. 10 minutes isn't a huge amount of time to go through what has been, in some respects, lifetimes of experience and really some awful human tragedies. But there are really some broad themes that have come out. I won't talk about specific employers unless I can really evidence some of the issues, but I will talk about some of the round. because it's fair to say what we've seen in the past few months has really exposed some of what you might consider to be the home truths of working and living in the UK. And I think the biggest one, to be frank, is the inability of even some of the biggest employers in this country to properly manage the risks to their workforce from COVID. One of the biggest kind of homilies that have been reported back to me for years was that we could trust employers to do the right things. Employers didn't need huge amounts of state intervention. We didn't need huge amounts of red tape or enforcement. And I must say this not just as a trade unionist for the past 12 years, but someone that worked at the HSE for a decade before that. There's always been this kind of underlying belief that employers would generally do the right thing. And that's been exposed in the past few months, I must be frank. There have been numerous occasions where we've thought that employers that had a good handle on things, that were taking this seriously, just didn't have the competence, didn't have the expertise to properly both assess the risks and then put the measures in place that were needed. Now, that wasn't an issue in some respects because we've got in many workplaces very good, strong organisation to hold employers to account and to help them in many cases get to where they need to be. But in lots of other cases, it was either a case of simply furloughing the workforce or just expecting people to muddle on almost regardless. A lot of that wasn't helped, I have to say, by some of the measures that were put in place by government and a lot of mixed messaging, and I'll come on more to that in a moment. But the general understanding that we'd had that employers were very useful in terms of being able to work with us, being able to actually understand for themselves what their issues were, knowing what their workforce was going through, almost vanished overnight, literally within weeks of coronavirus really beginning to hit the economy. So there was a big learning point for, I think, myself, my colleagues internally within the GMB and probably widely across the trade union movement in terms of our expectations. And the way that manifested itself for our members was really an awful lot of fear and uncertainty about what they were coming into work to deal with. You know, for the most part, our members are, I wouldn't say entirely, but probably we've got 630,000 members. And I imagine somewhere between 2/3 and 3/4 effectively kept working as emergency workers and key workers through that period. So for many of them, there was no break. There was no furlough. There was no time away from work or working from home. They were still in the front line in whatever form it may be it public services, food manufacturer, retail. And as a result, their kind of live experience was having these changes implemented while they were working. And that meant an awful lot of very, very quick decision making, not always very well advised decision making, an awful lot of goodwill being eroded quite quickly because it was clear that particularly local managers simply didn't have a handle on what was going on. And that as a result, some very, very shady practices, some very sharp practices were almost allowed to get through without any challenge. The ones I can share, the clearest examples of this were a company called Bakkavor, who are a large food manufacturing company. And we obtained footage from a worker who then subsequently became a member, video footage of their induction processes, which showed very clearly mostly BAME workers being told to continue working even if they're not feeling well, showed them being given what were very rudimentary scarves and snoods instead of proper protective measures. I mean, that's bad enough on the construction side, but these are people doing food handling and food preparation work, completely unacceptable. And the employer saw no problem with this. They genuinely believed they were doing the right thing by putting these measures in place because they hadn't been given anything from government to explain what needed to be done. And as a result, were fairly upset when that was leaked to the ITN and the Guardian and became basically front page news. We'd already reported that circumstance with that evidence to the Health and Safety Executive. It is still under investigation right now, but we're still waiting for an outcome from that. And that was probably the most open and shut case I've ever seen of a clear breach of health and safety regulations. So the fact we've not been able to achieve any kind of positive outcome there, the company have improved, but it's been purely through union pressure, was quite an indictment. We saw huge breaches of social distancing and any kind of protective approach in logistics and warehousing. And some of the companies will be very known to you, particularly those that do home deliveries for almost everything you might need. And again, practically no enforcement of that, even when there was clear-cut evidence. And I have to say the work that Gus did, the presentation, the guidance that Gus produced back in April was incredibly useful for advising workers of their Section 44 rights and make it very clear to them what they could and couldn't and should do around using those and getting the evidence in place necessary to defend that action. But it really did just show up just many employers for what they were. And as a rule of thumb, where not just the GMB, but trade unions in general have been well organised, we've been able to get quick action. It's been appropriate action. We've been able to hold employers to the actions needed. Where we have members, but we don't have that organisational strength, it has very much been a free-for-all. And I think the second theme actually that flows from that is that the government very clearly saw this from day one as a public health issue. There's been very little understanding of the occupational.
I think we've just lost Dan there, haven't we?
Yeah, I can't see him, I'm afraid. He's
Yes,
frozen.
I have to just give it a minute, and then he might come back in.
At least we still heard the bit where he praised my document, though. So
Yes, that's the most important part, Gus. You should tell people about your document.
Oh, okay. Well, I produced in April a PDF which hopefully explains in a relatively clear way. It's written in a way that I'd hope that members of the public might be able to grasp as well how Section 44 and Section 100 work. And so if you didn't understand a word of what I just tried to fit into 10 minutes, then you can see me producing it over 10 pages in that document instead.
It looks as if we've lost Dan very sadly. He may come back in possibly, but perhaps. Oh, there he is again.
Apologies, everyone. The Wi-Fi completely disappeared on me there, so I was midway through going on a fairly serious rant about Public Health England.
Please continue.
Lack of understanding. So I'm sure that's the second time today this has happened. I'm sure it's exactly the same. I suspect somewhere the government is spying on me and knowing what I'm saying. But the general point was that Public Health England from the very start have looked at this as you might expect as a public health issue. And that's been a key determinant in some really severe policy outcomes. So we've argued from the very beginning that workers need to be provided protective equipment, particularly working at close quarters, particularly where working with the public, because they can't control the social distancing. The idea that somehow this 2-metre rule was adequate was a nonsense. And we were seeing, particularly in construction, but also logistics, engineering, manufacturing, people being put at real risk because they just simply weren't able to maintain the kind of social distancing guidance that the government intended. As a result, and we've now seen with recent announcements about the wearing of face coverings on public transport and more recently retail, there has been a shift, but unfortunately in many cases it's come far too late. So we know, and I know this from my own personal experience as a member of the Industrial Areas Advisory Council, that of the top 10 highest risk occupations for death from COVID in the UK, our members are in 8 out of those 10, and the 2 that are not GMB members are doctors and nurses. Now, as a result, an awful lot of people that have died from COVID probably, I couldn't say wouldn't have died, but would have had at least a fighting chance if the government had moved more quickly and had been able to put face masks in. One of the biggest frustrations that we have had are the number of times we've been contacted by members saying, look, I want to wear a face mask, I want to wear a covering, I'm happy to bring it in myself and pay for it, but the employer is saying that the government aren't advising this, there's no guidance around it. Their own risk assessment is saying there's a tangible risk here, but because the legal standard isn't that they need to provide something, I'm being told I can't wear it, particularly because there's a concern about somehow upsetting the public. And of course, by the time that almost the goalposts have changed, the public discourse has changed, it's become too late. So the government have not helped matters. The lack of enforcement, the lack of clear policy, the sidelining of the Health and Safety Executive in favour of Public Health England has caused huge amounts of undue concern. And we've been heavily reliant on working with employers and employer organisations to develop sectoral guidance, when really the job was there for the state to do that in the first instance. That will be a particular problem if the second wave comes. So it's not been a rosy picture. The one good thing I would say is that we have seen a huge amount of worker empowerment during this period. And I think it's absolutely right to say that this has exposed very clearly that workers will not stay at home. They will not take being paid statutory sick pay, or indeed in some cases no pay at all, on a basis of being precautionary without a real challenge and a fight. And we've seen that in a number of instances. As I said, the guidance from Gus in particular was extremely useful in this respect, not only in terms of making people aware and making them aware of the rights they had because of the danger they might face, but more importantly, particularly in terms of any second wave, understanding very clearly for employers and government that you can't expect people to be told to stay at home for 14 days on £94.25 a week when they're used to earn an awful lot more than that. The reality is, and it's the same practically for every member in every sector, that where that minimum is either statutory pay or no pay, the simple answer has been, well, we'll come into work. There was a very good article the other day in The Guardian that we helped resource for Untitled Chapter about the care sector. And it made the point very clearly there that members are not being paid enough to stay at home if they're told to self-isolate. And as a result, they will have to come into work. And that puts potentially very vulnerable people at extremely high risk. That's not ideal at the best of times. And clearly, we'd never advise anyone's going to work. But at the same time, there is a genuine concern there. And that, I'm afraid, will only get worse if we do end up with this second wave coming. But it has put great power in. We've had a big increase in membership in this period. We've had an awful lot more people coming forward to volunteer as both health and safety reps and more generally as workplace reps, which is very welcome. It's shown the power that workers can have actually when they do start taking these issues forward for themselves. And it's shown the power of collective action. Gus made the point very well about those Section 44 rights being individual rights. But actually, in many cases, what we've seen is a real urgency and a real collective urgency to take action together. And in many cases, just the threat of doing that has forced employers to really change their approach to issues. So that's been very, very welcome. Two other things I would say in closing, really. One is that it's obvious, even now, that employers are not using this kind of trough, or a better term, this peak, and now the subsequent move away from severe numbers of COVID cases to really plan for what's coming next. The general approach seems to be, we're over the worst now, we're looking to business as usual. We can't keep putting these measures into place. I was on a different meeting this morning in the construction sector, and a couple of things were apparent very quickly. One was that one of the largest sectoral organisations in the construction industry had just made their head of health and safety redundant, which is an interesting move during a period of pandemic such as this. But also they were looking at removing a lot of the social distancing measures in place from their sites, because the feeling was it was no longer necessary, because the R numbers were no longer at a place where they thought that was appropriate, which will be hugely problematic if those figures do go back up, and all of that information, all of that precautionary activity needs to be reinstated. So we're at the moment in a bit of a position where we're saying to employers, particularly large employers who kind of get this already, you need to maintain what you're doing. And for most other employers, it's a case of, look, get your house in order now, because we are looking at a very severe second spike. And as a result, if you don't have measures in place, if you're not using this time to update your risk assessments, to look at your workers who are shielding, to understand what their risks are, particularly for those workers who've got underlying health conditions, who are BAME workers, who may have disabilities, you need to make sure that these people are protected, because all of this now is reasonably foreseeable. And it's not, I'm afraid, certainly from our point of view, sufficient to say, well, there's a lack of guidance from government, there's a lack of clear direction from government, and as a result, we don't feel we need to do anything. It's pretty clear cut, certainly from the people I speak to, both in terms of the members, but also in terms of academics, experts, people like yourselves, that we will be looking at a second spike. The length of that second wave does not look particularly great. My suspicion is it will be sooner rather than later, and it will be more severe than the first wave was. We've probably all seen the figures suggesting 120,000 deaths this time around. I suspect it may well be more than that. An awful lot of employers are not preparing for this in anywhere near an adequate way. And I suspect as a result, we will see a huge number of Section 44 claims coming down the line. We've been trying to avoid that where we can because of the concerns about the amount of time it will take to process. But I think it's almost inevitable, particularly when you look at the reopening of the hospitality and leisure sectors and the kind of impact that's already having in terms of worker safety. And the final point I would make, and it's not unfortunately a pleasant point, is that the longer term, I think, with all of this is going to be an absolute tsunami of mental health issues. One of the biggest pieces of feedback we get almost across the board in every sector is that workers are struggling at the moment. Those that are in precarious work are really concerned about their future prospects. Those that have families are concerned about their children's futures, their health. A lot of people are worried about their ability to pay their mortgage going forward. A lot of our members in very well organised, very strong sectors, the gas and utilities sectors, have real concerns about the work they'll be doing in a second COVID outbreak and how that may affect their health. So no one really has been unaffected by this. There at the moment, I think, has been almost a bit of a war spirit in terms of getting through this period. And my big concern would be that actually we're almost at the end of the first skirmish. This will be a long campaign, and it will be, unfortunately, a very severe campaign for most of us going forward. The government does not seem to be particularly aware of that. If they are, they're keeping their cards very close to their chest. We've called for a number of measures to be implemented, not just in terms of economic policy to ensure people don't lose their jobs, but in terms of putting support in now to guide people through the next period in terms of their mental health. But it doesn't seem to be particularly well received. There appears to be a bit of an approach of, to extend that war metaphor, almost a Blackadder goes forth kind of general Melchett approach, the British pluck and spirit will get us through this. I would love to think that's the case, but unfortunately, I don't think it will be. And now is not the time for amateurs. It is the time for the experts to take over. That is long overdue. But speaking of experts, I shall open the floor to Grahame and to the panel. But thank you to Grahame for Ernest for the invite, and I hope that's been a useful update.
Dan, it's absolutely our pleasure. We will go to some questions now. If you want to ask a question, please do raise your hand with a little raise your hand function, and I'll go around. We've had a few questions in from John Morgan, who tells me that he's out on a run, and if that isn't commitment to multitasking, I don't know what is. So he's asked that I ask his questions rather than see his sweaty face. The first one is something that I was going to ask about, Gus, and it's something that you and I have discussed in the past, actually, but I'd be interested in your perspective, Dan, as well. There's one thing that your place of work is a risky place to be. But what if your main concern is not so much that the workplace is dangerous, but getting on the tube, say, or getting on the bus is dangerous? Is it your view, Gus, that there are statutory protections there? And Dan, what's your experience of that particular issue?
So I've got good news and bad news for claimants who want to make claims that there's serious and imminent danger from public transport. The good news is that for some reason, the government in 1996 didn't specify in the legislation that the danger has to come from the workplace, even though the directive that it implements does. So employers could argue that that should be read into the primary legislation. I think that's a bad argument for employers to take, because Parliament is entitled to enact EU laws wider than the directives they implement, just not more narrowly. So that's the good news. The bad news, I'm afraid, is about the causation test. And what I mean by that is this. If you say to your employer, I just can't get to work anymore, then the tribunal may make a distinction, if you're dismissed, between the employer responding to your protected conduct and or responding to the fact that you're just unable to get into the doors. Now, that might seem a really narrow distinction, but remember when the Icelandic volcano went off, or if there's a train line that gets you to work that suddenly stops operating, like Southern Rail stopped operating. Employers don't have to employ you any further if the reason why they've decided to dismiss you is that you are unable to do your job. And that's slightly different to responding to your protected conduct. And so that is a really complicated issue. And employers, I think, would have to look at reasonable adjustments, not technically reasonable adjustments under statute, but whether you could do it from home, whether you could vary start times, etc., before dismissing fairly. But if someone has formed the view, even if they're entirely reasonable in doing so, an 80-year-old diabetic man who's still working but has to get the central line to work isn't going to want to get on the central line, my view is the employer is probably able to say, I'm terribly sorry, we agree you're being reasonable in not coming in, but if you can't do your job, we can't keep you on the payroll. That's probably the right advice. I wanted to very quickly respond to something that Dan said, which is I have written that these rights are individual, not collective, but that isn't the full story. The individual needs to make up their mind that the test is fulfilled. The union can't make up its mind for the individual, but the union can advise the individual. And section 102 and section 44.2 says one of the circumstances the court will listen to is the union's advice. So when determining whether something's appropriate or not, an individual claimant that said, I saw an email from Dan Shears of my union, the GMB, that said it's dangerous in this factory, and we've got to think carefully about attending the workplace, setting out the pros and cons and what the employer is failing to do, and I know he's jolly competent and qualified, would be a factor the tribunal would take into account when considering whether their non-attendance is appropriate or not. So they are individual rights, but the union's involvement in shaping what people know is absolutely key. And there's no reason why unions can't, while treading very carefully, thinking about TOLCRA, advise their members about their rights under section 44 and 100. And I know for a fact, because I work with a number of unions, that they're doing exactly that.
Absolutely, Gus. That's spot on. And just to pick up that point about employers handling the travel to work issue, it's been a mixed picture, to be quite frank. The experience I've had is that most public sector employers are looking at this very seriously.
Yeah.
The way we've been trying to handle the situation in terms of travel to work has been to get them to think around the wider risk aspects of this, in that if I've got a number of workers who are coming into the workplace every day using public transport, potentially they're going to be at higher risk of being exposed. And because of the potential for asymptomatic exposure and transmission, that you may well have people coming into workplaces with no symptoms that are carrying COVID and therefore may spread it around your workplace. One of the things you can do to control that risk clearly, although it's out with your normal responsibilities under the Health and Safety at Work Act, is to look at where people are travelling in and try and help them with those arrangements. So in some cases, we've had employers laying on extra transport. So it's socially distanced minibuses, taxis if need be. Some employers, particularly those that are based in central London, are basically telling as many people as they can that can work from home to continue to do so, because it's understood that actually that public transport risk, particularly on the tube, is quite pronounced. And it's just easier for them as employers to manage that. Some have been fairly doctrinaire and said, no, we can't control this. This is not within our remit. So as a result, how you get to work is up to you. Those have tended to be the areas where we've had more cases and there've been more issues of concern raised. It's been a general rule of thumb that where that's been the approach, it's been part of a wider approach to this issue that's not been particularly constructive and very much focused around what employers should be doing for the employer rather than actually any kind of view on risk. But I think, again, the more that people understand that public transport is a risk, that not everyone has the availability to drive into work every day, and that many employers don't have the capacity for their entire workforce to drive in, there's a recognition of that. So we've been pushing that. We've been particularly pushing it as part of our work on disabled workers, vulnerable workers, BAME workers, because that travel issue has been a particular risk factor for those groups. And it is now getting a bit of an understanding, I think. But it's taking time. It's not been an easy process.
Gus, you had your hand up, but was that just to respond to the point? Yeah, I thought it was. A question that I have, perhaps this is more for Charlotte. Charlotte, I do a lot of work at the North East Law Centre, and I'm seeing sort of two contrary dynamics in the cases that I'm dealing with for them. One is perhaps uniquely in the world of employment law, that's a discipline where there are cases being generated by COVID, furloughing, redundancy, safe returns, and all the rest of it. So I'm seeing new cases like that. But I'm also seeing a lot of people saying, Grahame, if it's going to take me 2 years to deal with this, I'm just not going to bother. And do you think, on aggregate, this is going to cause an upsurge in cases, or is it going to be a downturn?
I think that there will be an upturn in cases, partly because I don't think that any member of the public expects their cases to take so long, and they just simply won't take into account that there is a backlog plus a whole load of new cases. I don't think I've had a single client who I've advised on how long a case is going to take who hasn't been shocked. So in that sense, I think we're going to have people not thinking tactically in that sense, not knowing what to do and putting their cases in. I mean, hopefully in what is now probably in a couple of years' time, some cases decided somewhere that makes a decision which affects lots of other cases and leads to settlement. For example, something to do with zero-hour workers being asked to go in and the difficulties around there. There are numerous cases that I'm sure are going to be very important, and there might be a breaking point in the future where we get some results in. But actually, I think that we're not looking at a positive outcome in terms of capacity. I think cases are going to increase. It's going to be very difficult for the Employment Tribunal to get back on their feet fully. And we're going to just be sitting, law centres especially, are going to be seeing people coming in the doors in a year and a half's time, having got themselves most of the way through a case and just either lost energy or just got themselves in a pickle because they don't know how to act. So I think we're really going to have to think, especially when we're talking about funding advice centres in the future, trade unions making plans, this is going to have effects that are going to have ramifications for at least the next couple of years.
Another one of John Morgan's questions, he asks, I wonder if the panel have views on the extent to which some workers will be able to retain some of the flexibility gains won, in inverted commas, through the crisis. He, in his practice, is not seeing any uptake in flexible working requests yet, but do you guys think they will come?
I've seen an positive side from some clients who work in office-based jobs where they're generally paid a bit more and they work solely in an office, and they seem to be reporting that they are being told to work from home more, that this is continuing in the future, health and safety items such as risk mats and things being bought for their home. So companies are looking to the future for those people. My fear is that it's going to become a two-tier system where people in industries who are required to go in, or their colleagues are required to go in for some more traditional industries such as retail and all these things, there will be an attitude that everyone has to go into the office and it's back to normal. And I really do think everyone's going to have to be quite careful, especially when making decisions about the reality of the situation, to look outside everyone's own working from home safe bubble and realise that employers are just going to be very traditional about things and not make those changes. And of course, that's going to have detrimental effects, especially if things like care for children continue to be problematic. Women are going to be disproportionately affected, especially in lower paid jobs, for a significant period of time, and we need to be aware of that.
So I think one thing to draw that together is think about reasonable adjustments claims when considering this. And my view is that people who weren't disabled before coronavirus, so say you are a 55-year-old or 60-year-old man with relatively well-controlled diabetes, well, it might be able to be said that the existence of a pandemic that has a good chance of rendering you severely ill might mean that there's a substantial adverse impact to your ability to do day-to-day activities, i.e. sitting within 2 meters of strangers, which is a pretty common day-to-day activity. And so people might be drawn into the definition of disability because the existence of the pandemic combined with their pre-existing conditions changes the way they do their day-to-day activities. And will it last more than 12 months? Well, it seems quite possible that it might. Now, the other thing that I want to say about that is, so when making requests for flexible working, if you're doing it on behalf of someone who may be vulnerable, A, think about reasonable adjustments, but also think about indirect discrimination claims, because almost everyone will be able to show that the first 3 criteria for an indirect discrimination claim is met, because almost everyone is either a man or has an ethnicity that isn't white, or crucially is older than someone else. And all you need to show for indirect is that compared to another group, you suffer a disadvantage. So if you are a 60-year-old white woman compared to much younger white women, you have a disadvantage from PCPs that expose you to coronavirus. Now, not all of those claims will succeed, but in every letter that people are writing asking for reasonable adjustments, if there's a reason whether it's age or race or disability that means you're particularly vulnerable from coronavirus, people should say that the failure to make any flexible working could be either a failure to make reasonable adjustments, discrimination arising from disability, or actionable indirect discrimination under the Equality Act. And those sorts of claims have the possibility, not the certainty, of being able to add individual respondents, which might get over any of the enforcement issues that Charlotte so rightly raises. So do remember and think about the Equality Act as well as the fascinating bits of the Employment Rights Act that I've talked about so far.
If I can just come in there at the end, Graham, I think the experience for members has been very similar to Charlotte's in terms of the higher paid, better paid members who are able to work from home relatively easily being able to do so. My suspicion is that we'll see that continue for a while yet, because for employers, the productivity gains of this period have been quite high. Certainly within G&B, and I'm involved with the return to work aspects and processes for the union, there was a real concern that because of the unique nature of what we do, there'd be a big problem in terms of servicing members. Actually, that hasn't transpired at all. If anything, people are now working for longer than they normally would because they're not commuting and they're at home. They've got more control over when they work and what they do. But that productivity, I suspect, will tail off over time, particularly when schools go back in September. There are going to be some severe issues about people's long-term ability to work from home in what are, at the moment, temporary circumstances. So if that is going to be a permanent state of affairs, there will need to be substantial investment, as Charlotte pointed out, in technology to do that and in equipment to do that. But on the other side of things, to make workplaces COVID safe, particularly offices, I know our own offices in central London, when people return to work, they won't be open plan offices. Everyone will effectively have their desk turned into a cubicle. And that will radically change the nature of being in the office. There won't be the opportunities to socialise in a way there were before because of the COVID risk. And I suspect people will find that sitting in front of a computer screen for 8 to 10 hours a day in some cases, in what is now a walled off partitioned area, not really able to talk to colleagues very often without sort of throwing their voice over an 8-foot screen, is not going to be a pleasant experience. So I suspect in lots of cases, people will go back to offices for a short period of time and they'll find quite quickly it's no longer the pleasant experience it was. And as a result, they may want to go back a longer time home. The other thing I suspect we'll see, and this is purely anecdotal, but a number of businesses that we have substantial membership in are going through periods of very serious financial turmoil at the moment. And if you don't need to service very large offices, particularly in large urban areas, there's quite attractive savings to be made by either stopping rents early, closing offices down. So I would not be surprised at all if we do see a bigger picture move to home working, even if the workforce don't necessarily want it.
Certainly in the legal profession, we know that that's happening. Guys, it's been absolutely fascinating, and I'm extremely grateful to you for coming and speaking to us. I could certainly ask you questions about it all night. This has been the first employment group discussion that we've had in a long while, and I'm hoping we can do a lot more in the future. And I'm also hoping that we will be able to have some in-person events at some point soon, either. And I'd like to organise a social event, and of course everyone will be invited to that social event without any law chat, just political chat, I suppose. I've got to plug the fascinating talk that the Society of Labour Lawyers is organising tomorrow night at 5 o'clock. It's on the duty solicitor scheme and access to justice, and it's being organised by the Housing Group. We've got a fantastic range of speakers who have really deep knowledge of that area of law. Wendy Pettifer, Sue James, Simon Mullings, Matt Howgate are all going to be talking. So I hope that if you're into that kind of thing, you'll join the Society for that. But other than that, I want to thank the speakers once again, and thank you all for joining. And thank you to Joe for organising as well. Thank you all.